Thank you very much. Let me begin by thanking the organizers, Mike, and Steve, for inviting me. It's really a pleasure to be here. I feel lucky to be here. I'm keenly aware of the collective knowledge and wisdom in this room about the history of American constitutional law, and I'm a relative newcomer to this topic, so I'm really looking forward to your comments and suggestions and challenges. My topic is the necessary and proper clauses in the Constitution, and I use the plural form to emphasize that there are in fact three separate provisions of what we ordinarily call the necessary and proper clause. The first provision refers to the foregoing powers that are enumerated in Article 1, Section 8. The second half of the necessary and proper clause is what I call the all other powers provision. And that says that Congress shall have the power to make all laws which shall be necessary and proper for carrying into execution all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. And at one point in the paper, I go ahead and give each half of that all other powers provision a name. I call the first half the government powers provision, and the second half the department or officer powers provision. And the main point of the paper is, in the first instance, to call attention to the fact that, in fact, the necessary and proper clause does have this complex internal structure, that it is comprised of these different components, and then more importantly, to walk through some of the well-known history of the convention, the drafting history, the early debates around the Constitution, the ratification conventions, well-known Federalist Papers and the like, armed with this distinction, armed with this sensitivity to the different parts of the necessary and proper clause. And what I point out is that, in fact, many of the best-known explications of the clause, in fact, are referring to the all other powers provision, not the foregoing powers provision. I think the contemporary conventional wisdom in the legal academy as well as in the courts is that the most important part of the clause is the part pertaining to the enumerated powers. And the standard doctrine is that the clause provides the government incidental powers to carry into execution the enumerated powers, but not more. What I argue in the paper, and I'm aware that this is a bit of a bold and unconventional argument, I argue in the paper that that is not the understanding of the clause that was held by many in the founding generation. I don't think it was the understanding of the clause that was intended by the drafter of the clause, James Wilson, nor of the predominant number of delegates to the convention, but it's an open question about what happened after the convention and how we understand the ratification debates. So some of this history that I call attention to, and I think it's worth just kind of running through, in Federalist 33, Hamilton quotes only the all other powers provision. In his first speech to the Congress to explain why we needed a Bill of Rights, James Madison quotes only the all other powers provision. And he says that the reason we need a Bill of Rights is because in light of the provision, the all other powers provision, Congress has extraordinary powers to achieve any of the ends for which the government was created. In his law lectures, James Wilson, again in explicating the powers of Congress, quotes only the all other powers provision. And as I point out in the paper, many of the leading anti-federalists, individuals like Brutus, an old Whig, Federal Farmer, and others, when they are calling attention to what they perceive to be the potentially dangerous aspects of the necessary and proper clause, they are often calling attention to the all other powers provision, not to the foregoing powers provision. This is what bothered them. The famous Marshall Court opinions on the necessary and proper clause, I think, also fall into this pattern. So as I point out, the first necessary and proper clause case, the Fisher case, a bankruptcy case, is one, again, in which the only part of the clause that's quoted is the all other powers provision. And I think there are reasons for that. McCulloch is obviously a complex opinion. There's a lot going on in McCulloch, but I make the bold claim that when John Marshall refers to the ends within the scope of the Constitution, He's actually referring to the ends that are set out in the preamble of the Constitution. And the reason he thinks those fall within the power of the government is by virtue of the all other powers provision. That was the standard Federalist reading for many years, linking the all other powers provision to the preamble. And in Osborne versus the Bank of the United States, Marshall makes this point explicit. He says the entire opinion in McCulloch was founded on this principle, this part of the Constitution, and he quotes only the government powers component of the all other powers provision. So I think there's a lot of evidence in the record to suggest that at the very least, this was an important part of the understanding, the original public understanding of the necessary and proper clause and what might be at stake. The brunt of the paper is a walkthrough of the drafting history, an explanation of how James Wilson might have drafted this provision and why he did draft it in the way that he did. I talk about the fact that the foregoing powers provision comes from the hand of John Rutledge, as far as we can tell, but the all other powers provision is Wilson's contribution. And I point out that Wilson, during the period of the Articles of Confederation, was one of the leading champions of implied powers, and that he and the nationalist allies around him, people like Gouverneur Morris, Robert Morris, and others, were wed to this conception of government for fairly systematic economic and political reasons. I also talk a little bit about the corporate law background to the necessary and proper clause, and I think this is an interesting point as well. Wilson consistently held to the view that the Constitution was not a contract. That was one reason why a Bill of Rights was inapt. It was an act of incorporation. And it turns out that Wilson, of course, was a very sophisticated corporate lawyer. He was the lawyer for the Illinois and Wabash land companies. The company owned vast tracts of land in the West. He had been arguing for years that Congress had the implied power to recognize the titles of those companies. He was also the lawyer for the Bank of North America. And in defending the charter of the Bank of North America against its discontinuation, he argued that Congress had the power to charter the bank, even under the Articles of Confederation, despite the presence of Article II, which apparently denied to the government powers that were not expressly granted. So I won't walk through further evidence that I gather in the paper. I want to take a different direction just for a moment and say what might be at stake here. If I'm correct that, in fact, there's been a systematic misreading and misunderstanding of the necessary and proper clause, what's at stake? Well, I think what's at stake might be our very understanding of the Constitution and the government that it creates. We are currently in the midst of a trend in constitutional law that begins, I think, in the mid-90s, of narrowing the nation's power. That's the term that Ninth Circuit Judge John Noonan used in a book about the line of cases that we're all familiar with, the federalism cases, Lopez, Prince, Birney, Seminole Tribe, Alden, Morrison, Garrett, and others. And what I'd like to suggest is that a better understanding of the complexity of the necessary and proper clause, and in particular the all other powers provision, and why it might have been inserted into the Constitution, what the drafters intended, might force us to reconsider some of these doctrines that have now become embedded in constitutional law through our federalism jurisprudence. So with that, I'll just leave it and look forward to your conversation. Thanks.